Okay, so we go for the last presentation of this morning. Professor Nance is the speaker. He is professor and he's very well known for his works and the recent publications that the speaker is presenting.
Of belief. Professor Nance, you have your time, and a big applause for you.
Thank you very much for the introduction. There it is. All right. Dr. Ferreira has given us much food for thought regarding the construction of burdens of proof within a given legal system, and my talk will take this to the international level. Specifically, I will talk with you about the problem of choice of law with regard to burdens of proof. To set the stage, there it is. I present a simple example. The court in one state or country, which I will call the forum state, is called upon to decide a civil case that has events and people with contacts in another state or country, which I will call the non-forum state. In most books, it's called the foreign state, but if I say foreign and forum, we'll get lost in a hurry. And you'll notice I said civil case, and that's because in criminal cases, you will never have a forum state applying the criminal law of another jurisdiction. That's a basic principle of international law. Instead, a forum state might extradite a defendant to be tried in the original jurisdiction where the crime occurred, but you wouldn't have the forum state applying the criminal law of another state. So if you're only interested in criminal law, you might well want to tune out from here on in. All right, so assume that the forum state court has considered allegations of breach of contract or tort or some other civil claim and has decided that because of the contacts with the forum, the non-forum state, the proper choice of law for the forum court is to apply the non-forum state's substantive law governing the cause of action. My question then is, which state's rules regarding the burden of proof should control? Now, if any of you work in this field, you'll know the traditional answer. It is to invoke the highly contested substance procedure distinction and to select the procedural rules of the forum. Procedure has always been taken to include the burdens of proof, so burdens of proof would be supplied by the forum law. This is the position taken, at least nominally, in Section 595 of the first restatement of conflict of laws and published by the American Law Institute in 1934, an approach to choice of law still followed in a minority of states in the United States and by many countries around the world. Here's the relevant sections from the first restatement. To illustrate, one of the leading cases was decided by the highest court of Massachusetts in a negligence action brought there based on an automobile accident that had occurred in the neighboring state of Rhode Island. At the time, both states had a cause of action for negligently causing injury, and both states recognized that the plaintiff's contributory negligence was a bar to recovery. If the suit had been brought in Rhode Island, the plaintiff would have been required to bear the burden of proving not only the defendant's negligence, but also his own freedom from fault. Whereas under Massachusetts law at the time, the plaintiff was required to prove the defendant's negligence, but the burden was on the defendant to prove the plaintiff's contributory negligence as an affirmative defense. The highest Massachusetts court in this case, in a very cryptic one-page opinion, held that burdens of proof are procedural, governed by the forum law, so the burden was properly placed on the defendant to prove the plaintiff's contributory negligence in accord with Massachusetts law. Now, this principle for burdens of proof was problematic in those situations where the non-forum cause of action did not have a direct analog in forum law, as it did in the Massachusetts case. When there was no direct analog in the forum law, there would not be any rule in the forum rule for the burden of proof. Without a cause of action, neither the legislature nor the courts would have had occasion to specify a burden of proof. Accordingly, courts faced with such unusual non-forum causes of action would often say that the non-forum proof rule was inextricably intertwined with the non-forum substantive law. Hence, the traditional choice of law preference for the forum rule was subject to an exception, which you see down there at the bottom. This exception, however, did not appear in the restatement sections itself, but only in the comments following the section, comments made by the drafters of the rule. Moreover, this exception never adequately explained the case law. Some cases selected the non-forum proof rule even when the forum state had the same cause of action, but just had a different burden of proof. In other words, they reached exactly the opposite conclusion that the Massachusetts court had reached. Sometimes these courts would try to avoid rejecting the conventional syllogism about, well, it's procedure, so it must be governed by forum law, by reinterpreting the burden of proof rule in the non-forum state as a condition on the cause of action itself, thus making the proof rule look more substantive. But rarely was there any explanation of why this made sense in one context but not in another. The cases applying the general rule and those applying the exception were simply irreconcilable. Now, around the time of the publication of the first restatement, which was 1934, a sea change of ideas was beginning in the United States. Part of it was a rejection of the kind of formalism that these early cases represented. Another part of it was doctrinal. In 1938, the United States Supreme Court decided Erie Railroad Company versus Tompkins, which radically changed the law of federal courts when they exercised jurisdiction not based on federal statutory or constitutional claims, but rather based merely on the fact that the parties are from different states or countries, known as diversity of citizenship jurisdiction. The Erie decision was understood as requiring that federal courts exercising such diversity jurisdiction apply state substantive law, but federal procedural law. And this preference for federal procedural law became a central premise of what is called vertical choice of law in our federal system. It was reinforced by the adoption of the Federal Rules of Civil Procedure in 1938, which specified a uniform set of procedural rules for federal courts, regardless of the basis of subject matter jurisdiction in those courts. Although the grounds of the Erie decision are still debated, one of the undeniable goals of the new doctrine was to prevent plaintiffs from obtaining a more favorable governing substantive rule merely by filing in federal courts than they would encounter had they filed in state courts, and also to prevent defendants from doing the same thing by removing a claim initially filed in state court to federal court based on diversity of citizenship. Now, the problem was that it was quickly realized that the differences in procedural rules between the state and federal courts also created incentives to engage in such forum shopping. And this forced the federal courts to expand what was considered substantive, to embrace a variety of rules that would normally have been considered procedural, meaning that federal courts used many arguably procedural rules of state law when adjudicating rights derived from state substantive law. In particular, very early in this process, the burden of proof was recognized as substantive for such vertical choice of law purposes, even though it still was nominally considered procedural for horizontal choice of law purposes. So depending upon whether you were talking about federal versus state or state versus state, it would have a different characterization. Now, to this day, this vertical choice of law jurisprudence has placed considerable pressure on the substance procedure distinction in horizontal choice of law in the United States. always in the direction of expanding what is considered substantive. The basic principle expressed by academics nowadays is that once the forum court chooses to apply non-forum substantive law, the forum court should employ as much of the law of the non-forum state pertaining to the issue as is possible, whether that law is thought to be substantive or procedural. The only limits usually acknowledged are that it is unnecessary to adopt technical procedural rules that have minimal impact on the result, or would be excessively costly or inconvenient to replicate in the forum, or that violate some specific federal statute. This, as I said, is the dominant academic preference among American conflict scholars, but the case law is not really cooperating with the academics. Consider the second restatement of conflict of laws, published in 1969, trying to capture the evolving case law. If you read section 122, you'll see that it drops the category of procedure entirely and replaces it with the somewhat more descriptive phrase, rules prescribing how litigation shall be conducted. This section says that the forum court usually applies its own laws of this type, and the comments justify this by noting the inconvenience of doing otherwise. Here, the drafters explicitly refer to rules of pleading, service of process, execution of judgments. So far, the restatement aligns reasonably well with the academic opinions about sound social policy. But the restatement's drafters explicitly state that burdens of proof are a special and close case. Again, reflecting the diversity of judicial opinions, the second restatement provides the same default principle regardless of regarding all the various issues that relate to the burden of proof. It's in sections 133 through 135. And this default rule favors application of forum state law again. Now, you'll see there is, in this case, under the second restatement, there is an explicit exception, an escape clause. And in this context, in the second restatement, it's worded differently. It's worded, unless the primary purpose of the relevant rule of the state of applicable law is to affect decision of the issue rather than to regulate the conduct of the trial. So instead of the substance procedure distinction that had prevailed under the first restatement, many American courts now invoke a distinction between rules designed to affect the decision of the issue, on the one hand, which would be taken from the lex causae, the law of the cause of action, and rules designed to regulate the trial, which would be governed by forum law. Commentators, however, have observed that this is not particularly helpful, given that all rules that affect the decision do so by regulating the trial, and given also that all rules that regulate the trial have at least the contemplated potential to affect the decision. In particular, it seems hard to imagine a burden of proof rule that is not designed to affect the decision. What else would it mean to say that a party has a burden? This, once again, is the dominant view among commentators. They presuppose that what it means for a rule to merely regulate the trial is for that rule to have no significant effect on the decision in the case, such as a rule that simply reduces the public cost of litigation, or a rule that coordinates the parties' conduct so as to reduce both private and public costs, but without having any impact on the decision. And there are such rules, if you think about it, what kind of paper to file your pleadings on, and that sort of thing, just things that make the process of litigation go smoother. But there's an important observation to be made here. For choice of law purposes, there are two types of ways in which a rule, a proof rule, might affect the decision of the issue. This is not recognized in the restatement or in the cases very explicitly. One is rules might be designed to systematically favor one side or the other in a dispute, or one class of litigants over another. And the second is rules designed to affect the final decision, but without regard to whether that will benefit one class of plaintiffs or defendants. The important observation here is that for choice of law purposes, type 2 effect rules should be grouped together with rules that are designed merely to regulate the trial. That is, they're designed to affect the decision of the issue, to be sure, but not to favor one side or the other. What the opinions mean when they refer to proof rules or other kinds of rules that affect the decision is rules that affect the decision in a certain way, in the manner described in type 1 rules, by intentionally favoring one class of litigants over their opponents, rules specifying or altering the law's preference for one such class over another. Most American commentators in the conflict of law field neglect the importance of type 2 burden of proof rules. Now, in other areas, this distinction is recognized. The most important examples of type 2 rules are rules that are designed to improve the accuracy of the resulting judgment. Most admissibility rules, other than privileges, are of this type, applying indiscriminately to both the plaintiff and the defendant. Whether any such rule is wise or unwise is usually debatable, but what is rarely seriously challenged is the idea that such rules are intended to improve the accuracy of the resulting verdict. And it's readily conceded that this means that most forum court admissibility rules apply even when a non-forum doctrine of tort or contract law is selected to govern the dispute. And there are other sections in the restatement to that effect. But what about burdens of proof? Is there some aspect of proof burdens that is analogous to admissibility rules in this respect? If not, then all burden of proof rules are of type 1, and the choice of law principle, at least the default principle, ought to be the opposite of what their second restatement states. And that is the conclusion of most American conflict scholars. Now, the second restatement does at least recognize a distinction that Anglo-American evidence scholars routinely emphasize, the distinction between the burden of persuasion, my apologies to Dr. Ferrer, or the risk of non-persuasion, and the burden of production. But the restatement provides the same default principle and the same escape principle for both kinds of burdens. Take a closer look at that. There's section 133, which governs the burden of proof, which, if you read it carefully, refers to the risk of non-persuasion or the burden of persuasion. And section 134, which governs the burden of producing evidence. But if you read them, you'll also see that they, again, apply the same rule, identical. Choose the forum rule unless the rule was designed to affect the decision, whatever that is intended to mean. All right, so we should take a closer look at these two burdens. Each of them has two parts, which came out in Dr. Ferrer's discussion. And I'll mention that what Dr. Ferrer was talking about was all burdens of persuasion. He was not talking about the burden of production in any of what he was addressing. So the burden of persuasion, or risk of non-persuasion, is allocated to one side or the other and rarely moves during the entire process. It's applied by the fact finder during deliberation. Its severity is specified by what is usually called the standard of proof, such as proof by preponderance of the evidence, or proof by clear and convincing evidence, or proof beyond reasonable doubt, which actually does rarely happen in civil cases. All this is determined by statute or judicial decision for each cause of action. By allocating the burden with regard to certain ultimate material facts, the law determines whether each such fact is part of the plaintiff's prima facie case or instead part of an affirmative defense. Now, this burden is surely a type 1 effect rule. It specifies the degree to which the law favors the plaintiff or the defendant. By making the standard of proof relatively high, say by invoking the standard of proof by clear and convincing evidence, it is common, as is common when the plaintiff alleges fraud or malice, for example, the law favors defendants with regard to those claims. By placing the burden of persuasion on the defendant for an affirmative defense, such as the expiration of the statute of limitations, the law favors the plaintiff with regard to that defense. And so on. Making these distinctions is not unlike choosing whether or not to add an element to the plaintiff's cause of action, what they must prove. Adding an element favors the defendant, and intentionally so. Removing an element favors the plaintiff. To this extent, the mainstream American conflict scholars are correct. The default principle of the second restatement is backwards. It should specify that non-forum law governs the burden of persuasion on an issue that is otherwise controlled by non-forum substantive law. Indeed, judicial decisions that purport to follow the second restatement have generally held this way, although there's not a whole lot of law on this point. But what about the burden of production? The burden of production is an idea that is, of course, very different in Anglo-American adversarial trials than it is in trials conducted on the traditional civil law model. In Anglo-American trials, this burden compels a party to produce evidence at trial. The allocation of this burden can shift back and forth during the trial, and when the evidence is ultimately submitted by the court to the fact finder for decision, there is no longer any burden of production at all. That is, the burden of production is a collection of rules used to assess whether each party has done what it must do in terms of the presentation of evidence in order to be entitled to have a fact finder rule on the merits. Now, these sufficiency rules have numerous purposes. Sometimes they allow the trial court to save time and expense by terminating easy cases without the necessity of jury deliberations. Sometimes they allow a trial court to prevent or overrule an irrational decision by a jury. Sometimes they merely allow the trial court to remind the jury not to be overly legalistic in its assessment of evidence, not to check its common sense at the door, as it were. Sometimes they allow the trial court to place pressure on a party to present evidence that the party would not otherwise choose to present. And sometimes they allow the appellate courts or legislatures to control the trial courts in doing the foregoing things. Courts and commentators seem to be quite conflicted, if you'll excuse the pun, over whether burden of production rules are in type 1 or type 2 effect rules. Some emphasize that in the absence of any evidence on an issue, the burden of production cannot be met, and so it is outcome determinative. These commentators infer that the burden of production is a type 1, designed to favor defendants. But this argument is unconvincing. It's little different from observing that, under the right conditions, an admissibility rule will be outcome determinative and favor the defendant. True enough, but under the right conditions, either an admissibility rule or a burden of production can also result in a judgment for the plaintiff. That's just the necessary consequence of using rules that must be enforced. It does not mean that the rule is there to favor one side or the other. At the other extreme, some courts and commentators emphasize that one of the parties must go first in presenting evidence in an adversarial trial, and it really does not matter which one does. It's like choosing whether to drive on the right side or the left side of the street. One must pick a convention so that everyone knows how things are to be done, and it's a simple coordination problem. By this logic, the burden of production is merely a matter of the order of presenting evidence. That is, it's neither a type 1 effect rule nor a type 2 effect rule, but rather, in the restatement's terminology, a rule regulating the conduct of the trial. Indeed, that seems to have been the thinking of the drafters of the Second Restatement that led to their chosen default principle. But it ignores the many functions I just noted, functions that relate instead to improving accuracy as well as reducing costs and achieving coordination. These accuracy effects are real, and they can result in changing which party wins. But they are not type 1 effects. They're not designed to favor one class of litigants or one kind of claim. They're type 2 effects. So, in the book that I published in 2016, the site is up there for you, I placed the burden of production within the context of a wide variety of rules, the collective purpose of which is to manage what I called Keynesian weight of the evidence. The name comes from some fascinating suggestions by John Maynard Keynes in his early book on probability. Keynesian weight is different from the weight of evidence that lawyers are accustomed to talking about. We usually think of weight of evidence as the degree to which the evidence favors one side or the other. Keynesian weight, on the other hand, is a measure of the degree of completeness of the evidence, the extent to which the tribunal has been provided the evidence that is available to be obtained and considered. In adversarial adjudications, rules managing Keynesian weight include, but are certainly not limited to, rules of mandatory disclosure and discovery, many rules of admissibility, some rules requiring corroboration, most rules permitting a court to invite adverse inferences from a party's withholding or destruction of evidence, and many rules about the sufficiency of the evidence. I can't here try to summarize the lengthy arguments presented in that book. I'll just observe that the burden of production is one component part of an integrated and evolved system for practically optimizing the evidence considered by the fact finder. By practically optimizing, I simply mean attaining the best trade-off possible between the improved accuracy that comes from increasing the evidence available and the costs of various kinds of obtaining additional evidence. And the main point to emphasize here is this: whatever the extent and nature of these trade-offs, augmenting the available evidence improves expected accuracy of decision. That will often affect which side wins, but it does not mean its point is to favor one side over the other. Rather, the point is to improve the expected gains or reduce the expected losses of decision-making, regardless of which side wins as a result. Now, each legal system, whether adversarial or not, makes its own judgment about how to accommodate the interest in maximizing accuracy and other competing procedural goals, whether they be respecting the autonomy of litigants, incorporating the practical judgment of lay jurors, creating a highly structured decision process that minimizes the discretion of decision makers, keeping litigation costs down, avoiding inferential errors by jurors, or something else. Some commentators have observed, in fact, that the differences between legal systems in terms of their procedures can often be greater than the differences in the substantive norms that they recognize. And each system's accommodation of these procedural goals is entitled to be respected prima facie, even when the forum chooses to apply the law of a non-forum state. While some disturbance of the system is almost inevitable when applying non-forum substantive law, each legal system will and should try to keep this disruption to a minimum. So I conclude that the burden of production is more than merely a rule for ordering the presentation of evidence, but at least ordinarily it is not a set of rules designed to specify the degree to which the law will favor one side over the other. It is a type 2 rule that ordinarily should be governed by the law of the forum. On this point, the dominant view among American conflict scholars is wrong, and the second restatement is essentially correct. So, there are a number of important complexities and counterarguments that would have to be considered, such as if you have a different rule for the burden of persuasion and a different rule for the burden of production, then you have to make difficult choices sometimes about whether a particular rule is a burden of persuasion rule or a burden of production rule, and that can get tricky at times. So, meanwhile, my tentative recommendation, supported more by the case law than by the opinions of American conflict scholars, is that the choice of law rule, or at least the default preference, would be that the burden of persuasion should follow the relevant non-forum law, while the burden of production ordinarily should follow the law of the forum. If the United States moves more consistently in this direction, it will be converging on what I understand to be the emerging private international law norms in Europe. Thank you, and I look forward to your questions and comments.
Muy bien. Tenemos bastante tiempo para preguntas, así que creo que
we have time for questions. I hope I will be able to be more generous in the time given to people. So yes, fourth row over there.
Thank you. Congratulations, Mr. Nance. I found it very interesting. My name is Elina Mustaira. I'm professor of comparative law at the University of Athens, Greece. And I have written, I'm very much interested in US law. I have written 2 books on forum non-convenience and on US conflict of laws evolution. So I'm very much interested in all that. I wonder, I would like to ask you a question. This evolution from the traditional conflict of laws of the first restatement towards the second restatement, passing by the revolution of Brainerd Curry and Eret Zweig and everything, and all of these persons, has it led the US courts, either federal or state courts, to apply more foreign law than before? I suspect not. Let me elaborate on it. I think there's not an homogeneous application. Application of the rules. Several states follow second restatement. Several other states follow other conflict of laws rules. There is a discretion, a big discretion as far as judges saying is concerned. According to your knowledge and your research, are US courts following the same rules as far as burden of proof is concerned? Do they easily apply foreign law? Since private international law is the same as private interstate law in a US case. So is there a difference when there is an interstate law, so the non-forum law would be a state law, or when there is a private international law, when the non-forum law would be a foreign country's law? Is there a difference, or? Yep. That is my question. Thank you.
Okay, let me first ask you a point of clarification. You better give that back to her. Excuse me.
El micrófono.
Are you specifically referring to choice of law about burdens of proof, or are you talking about choice of law generally?
Yeah, I know about my so-called knowledge is about the general choice of law, but I'm asking about burden of proof specifically.
Okay, so let me ask, even though you're not asking it, I'll answer the general question so that people will have the orientation. So the general answer is that the United States follow a wide variety of choice of law methodologies. There is no uniform federal standard on choice of law. Some people have proposed that by federal statute. It's never been adopted. So we have, as many states and jurisdictions in the United States have their own choice of law rules. Many of them follow the traditional lex loci delicti and that sort of thing, the traditional pattern of choice of law rules. But a lot of them don't, and a lot of them have rules, choice of law rules that are quite sui generis. And overall, the general pattern of the revolution in choice of law has been to cause courts to have a greater preference for forum law as a general proposition. It's given them license to pick their own law on the substantive law of the case than the old law did. Now, on burden of proof in particular, I have seen very few cases that raise this, not enough to say that there's a pattern about international choice of law. I have seen enough cases at the interstate choice of law to say that the shift that I was talking about is real, that states that have moved to one of the newer modes of analysis are more inclined to accept the idea that the burden of persuasion should be governed by the non-forum law. That is happening in many states.
Por favor, Carmen Vázquez.
Muchas gracias por la presentación. Me ha gustado.
Thank you for your presentation. I really liked it. My question is about interpretation, but towards our systems, that is, the more Roman Germanic systems, because in our systems, the burden of proof is in recent years, there have been many procedural reforms in which, well, people have guaranteed that our systems are moving towards a more adversarial trend. Despite everything, there is no thought, as far as I know, about the need or the usefulness or even the role that might be played by burdens of production of proof or of evidence. But however, when there are problems, or problems regarding information that the parties have to submit in any judicial process, then the obligations imposed upon the parties, for example, when one of the parties has better access or easier access to evidence, well, then the burden that is imposed radicates exclusively on the burden of persuasion, on the burden of proof, because there is no burden of production of evidence. So then as well, in recent years, experts have talked about the fact that when that situation happens of greater probatory ease for one of the parties, well, then one has to change the burden of production of evidence. So then very often what has happened in some systems is that they defend that that change in the burden of proof takes place practically when the decision is made, when the judge is already going to make the decision, and not regarding the whole set of elements of evidence or before, if I well understand what you said, happens in the United States. So then my question is, first of all, when we talk about, well, in our systems, and we are moving towards a more adversarial space, are we missing out on an important part of the functioning of a system of justice that is adversarial, such as the one in the United States, when we are not discussing the burdens of production of evidence? And second question, if we are missing out on this, or if we are doing an adequate use, we're making adequate use of this kind of rules, when we impose those burdens in the persuasion burden instead of having a production of evidence burden. I don't know whether I made myself clear in my question.
I think you did. You are talking about the fact that you have an adversarial system that does not overtly utilize a separate burden of production. Is that right? Yeah. And obviously the use of the burden of production, or the clear distinction between the burden of persuasion and the burden of production, tended to arise as an artifact of the Anglo-American use of a jury trial. That's how we became sensitive to it. That doesn't mean it doesn't exist in bench trials or trials to a judge, but that's how we became sensitized to it, because it originally came up in the context of a judge ruling about whether the evidence could go to a jury. And that was the burden of production idea.
Si pudiera hacer ahí una precisión.
Yes, could I specify something? Because in the changes that have taken place in our systems, for example, there are systems such as the one in Chile or in Mexico, in which there are two subjects who decide. Because we have, on the one hand, a judge deciding on the admissibility of the evidence, and then a jury deciding on the other. So in those systems, at least at the level of general infrastructure, there is the existence of the same kind of decisors. There are two, in the same way as in the US. So it's not a jury, however, it's a professional judge. But however, it's a second judge or a collegiate organ deciding before well, the previous decisions carried out by a different organ.
Yeah, so I assume you have a motion or a decision that is made by the first judge about whether the evidence is adequate to go forward to the panel of judges that will decide the case. Do they decide something like that separate from just admissibility? No, so they just decide admissibility, but they don't get a chance to say that this case is so weak it should never go to the full panel. That's interesting. Yeah, that will make it hard to identify easily a burden of production, but you could still do it. I mean, you could, if the system wanted to do so, you could separately identify the idea of a burden of production and say that like we do in the United States, a thing called, when we say a presumption can shift the burden of production, but it doesn't shift the burden of persuasion. That's very common in the United States. So you use that kind of presumption, it forces the party to present evidence about an issue, but it doesn't shift to them the burden of persuasion. That's a tool that can be used to achieve that. And I don't know whether you have that in Chile, but that would be a possible way to manifest that distinction.
Yes, fifth row. Yeah, Emilio Alvarenga from Cordoba in Argentina. For us, it's a bit difficult to understand the American system, the US system, but linked to the previous question. We see in the procedural Argentinian horizon the figure of the dynamic burdens of proof, understood as the translation of probatory risk according to the impossibility of the subject that originally bears the burden of proof. So then this moving over the burden to who is in a better situation to prove, well then this is decided at the end of the process when there is probatory deficit, a lack of evidence in the process, then the judge, the sentence judge, imposes that who had to prove, who had to give the evidence was who was in a better situation to do so. Rather late, but based on general principles of goodwill. So how is this problem in the States?
Well, it does appear to me that if I understand what's going on in both Chile and Argentina, that's very late to be telling a party that they have a burden of proof on something only at the end of the trial. And that would not happen in the United States. If there is a shifting of the burden of persuasion, there will be a motion before a judge, and there'll be discussion of it. And it could occur at any stage in the trial, but it usually will occur fairly early when there's a question of whether some presumption shifts the burden or not. But the burden of persuasion typically stays where it was originally aligned. It doesn't move around anyway. So the party going in knows where it's going to be, and it doesn't shift. It's an unusual situation where the burden of persuasion moves to the other side during the course of the trial.
En la misma fila, por favor. Gracias.
Sí, quisiera escuchar.
Yes, I would like to hear your opinion about a distinction, a difference that we have between burden of production and burden of persuasion. For us, in Argentinian law, and I do understand Latin American law, and even kind of Spanish and American and Latin American law, the production burden is a risk taken by the party if it does not carry out the necessary actions for the evidence to happen, for the evidence to become part of the trial. The burden of persuasion for us is really a rule of judgment addressed to the judge and actually telling the judge what decision he or she must make if the burden of persuasion has not satisfied or met the standard of proof necessary for the action to be considered as proven. So then this burden of persuasion or rule of judgment typically and traditionally in Latin American law is formulated as a legal norm, as a legal standard. That is, the law establishes what the decision is that has to be made by the judge if the burden of persuasion has not been met. So what my colleague is from Cordoba is saying really is that in Spanish and Latin American law, this rule of judgment that is formulated by the legislator and determines the decision that the judge has to make regarding the fact that the burden of persuasion has not been met is being actually transferred over to the judge. That is, it's the judge, all in all, and not even the legislator, it's the judge who has to determine which the party is that is responsible for the burden of persuasion. And this is done by the judge before the decision, even before the probatory period. This is a standard or a norm that even has been sanctioned in the Argentinian civil code that started functioning some few years back, where it is established that it's the judge. The judge, in the moment in which the production of evidence is opened, it's the judge who must determine which is the party that has the burden of persuasion, in such a way that if that party is not meeting this burden of persuasion that's been imposed by the judge and not the law, then, well, there is an unfavorable decision. I don't know whether this makes it clear or how you can link this with Anglo-American law.
Okay, so there's two things there. I understand you be saying that there is a rough parallel to the burden of production in Argentinian law. It's not exactly the same in the sense that in our system, the parties actually introduce the evidence, examine the witnesses, and they select which witnesses to introduce and to testify, and so forth. Instead, you could have a sort of a lesser sense of burden of production in the sense that if a party nominates witnesses, for example, and the party fails to nominate a certain witness, then the magistrate might be under no obligation to interview a witness that is not nominated or something of that sort. There could be a burden of production in that sense. Yeah, so that's possible. I understand that. Now, on the second point about the burden of persuasion, generally speaking, in the United States, whether a cause of action is created by statute or by common law decision, it is rare for a legislature to specify the burden of persuasion. Sometimes they do, especially newer statutes do, but traditionally, legislatures would pass statutes, create causes of action, and never say anything at all about who had the burden on anything. And so it would be up to the judges when they would apply the statutes to say, okay, there's these 12 elements in the statute, you've got to prove these 3, and you've got to prove these 4, and, and they would just divvy it up at the time of the trial, or, in pretrial motions. I don't mean at the end of the trial, but parties would know going into the trial which ones who had to prove what. But it was very commonly a judgment made by judges, not by legislatures, and still is. But parties know what it is because they look at precedents. They say, you can look at the cases that have in the past decided this issue, and they'll know which side has the burden of persuasion on which issues. I think, is that what you're asking?
Por favor, arriba.
Muchas gracias, profesor.
Thank you, Professor, for your presentation of an extremely interesting subject. I have a question for you. At a given moment in your presentation, you said that between production and persuasion rules or burdens, there's a kind of control or safety filter for them not to take illicit evidence into the trial, taking into account that element, and then on the other hand, the existence as well of exclusion rules in the North American law system, plus the so many exceptions that exist about these exclusion rules. What's your opinion? If you already have exclusion rules in a parallel manner, well then with these persuasion and production rules, I don't know, or is there any kind of difference or as regards the role they play within the system? Thank you.
Well, okay, so the point I was making at the time was that the burden of production is just one piece of a complex mosaic of rules that function to regulate and control the amount and quality of the evidence that is presented to a fact finder. Now, could you do without any one piece of that puzzle, that mosaic? Yeah, you could take a piece out and the others would probably evolve to offset that and compensate in some way. But that's the system that's evolved. It's a grown system, to cite Ron Allen's discussion. No one orchestrated it, planned it from the beginning, but it has evolved and responded to various feedback loops in the process, and these rules fit into various parts of the puzzle to control and regulate the evidence that's presented. Now, I don't know if that completely answers your question, does it? Or is there more to your question? She's lost the mic.
Yes, it does reply to part of my question, indeed. Obviously, when you analyze kind of this like a piece of the jigsaw, like a mosaic, but within those jigsaw puzzle pieces, there's one that refers to exclusion rules, yeah? And those rules of exclusion are accompanying all this other set of rules that belong to the system. So what's your opinion then regarding the existence of rules of exclusion, even though you have so many exceptions, as I was able to read in North American doctrine?
Okay, there's two parts that I think might be responsive to your question. First, in the United States, when we refer to rules of exclusion, we're often not talking about what I referred to, which was admissibility rules. So rules of exclusion is a term of art that is usually refers to the exclusion of evidence that was illegally obtained by the police or something of that sort, where the purpose of excluding the evidence is to create appropriate incentives for proper police behavior and has little or nothing to do with obtaining an accurate verdict at trial. But then there are admissibility rules, and by the way, these two classes of rules are not even taught in the same course in the United States. The exclusionary rules are taught in a course called criminal procedure, and the admissibility rules are taught in the course on evidence. The admissibility rules that I was referring to are rules like the hearsay rule and the original documents rule and the character evidence rule, and those are generally aimed at trying to achieve accurate results in the trial. And those are the ones I was talking about. And yes, they all have many exceptions, and I agree with Ron Allen that both the hearsay rule and the character evidence rule have so many exceptions that it's hard to say that there's much left of them, but there is. I mean, you can identify cases, and they happen every day, where courts exclude evidence as violating the character evidence rule or the hearsay rule, so they do have an effect.
Hello, I'm Enrique Ballines from Universidad Complutense de Madrid. Thank you very much, Professor, for your presentation. It has been pointed out here how hard for us as being continental lawyers or scholars is to understand the concepts that you have been using. You have talked about burden of persuasion, that's including standard of proof and risk of non-persuasion at the same time, right? Mm-hmm. And you have then talked about the burden of production as being a separate thing. And I just wanted to comment that as far as I see things in a doctrinal way, at least in Spain, we don't deal with the notion of standard of proof, and that's what Professor Ferrer was talking about in the earlier presentation. So that raises problems for us to understand. And at the same time, it is very difficult for us to split between burden of production and burden of, or risk of non-persuasion. Because those who do not produce the evidence will be, at the end of the day, bearing the risk of non-persuading the judge. So we tend to see the burden of production and the risk of non-persuasion, what we call like sometimes carga formal de la prueba and carga material de la prueba, as two sides of the same coin. So if you are to produce evidence, it's because you're bearing the risk of non-persuading the judge. So the judge will not be ruling in your favor at the end of the day. So it is, and I come to the conclusion then, it is hard for us, I think, to buy the argument that the burden of production must be governed by the forum rules, and the burden of proof or the risk of non-persuasion shall be governed by the non-forum. Because we tend to see both things together.
Mm-hmm. Well, let me ask you this. Which part of it do you find more difficult to accept? If you think of them as the same, should it be governed by forum law or by non-forum law? What do I think? Yeah.
That's a good question. It depends on how you... we have a debate, not in Spain, but we tend to see the rules on risk of non-persuasion as being procedural rules.
The traditional
approach, that's right. And the Supreme Court here is very clear on that, and we don't really discuss much about this. But as far as I know, to the best of my knowledge, this is not so clear in other countries, such as Germany, for example, where they think that the rules on the burden of proof are of a substantive nature.
Yes, that's right.
So that changes a lot of things, because, you know, if you think that the rules on burden of proof are of a substantive nature, then that opens the field for choice of law and so on, and also for other things like agreements between the parties as to the shifting of the burdens and so on. And gosh, I wish I had an opinion on the nature of the rules on the burden of proof. Yes. But you made me think. I mean, I understand the point that when it comes to applying foreign law, it makes a lot of sense to bring the rules on the risk of non-persuasion, on the burden of proof with you to the forum, even those rules are foreign, you know. So that, you know, sort of leads me to the conclusion that indeed there are substantive rules, as they say they are in Germany. Right. You know what I mean? But still, it is quite difficult for me to, probably because of the way we have constructed the notions and so on, it's quite difficult for me to believe that you can actually split the burden of production from the burden of persuasion, or the burden of proof, the risk of non-persuasion.
Yes. A couple things. First, I agree with you about the EU law. My understanding of Rome I and Rome II is that they have incorporated the idea that the burden of persuasion on breaches of contract and tortious obligation, remedies is aligned with the substantive cause of action and the non-forum law. And at the same time, there is authority for the proposition that European courts will ignore the burden of production that occurs in American courts or Anglo-American adversarial courts, which makes sense because it's a foreign procedural device that they don't really have a complete analog to. And that's basically my point. The same thing should, I think, apply largely if you're dealing with interstate within the United States litigation. Now, the other part of your question about whether you can conceptually draw the distinction, the best illustration would be to think of a case that I mentioned in regard to another question that can come up. There are situations where an instruction is given in the United States to a jury, because it'd be a jury question, where an instruction would be given to a jury that would say, you may infer that this evidence is contrary to the interests of this party because they had peculiar access to that evidence and never presented it. And nonetheless, that does not change the standard on the burden of persuasion. In other words, there could be an instruction like that where it's the defendant who against whom the jury may draw an adverse inference, but the burden of persuasion is still on the plaintiff. Right? The plaintiff's still got to prove their case, but as part of that proof, the jury is entitled to consider the fact that the defendant had access to this evidence, peculiar access to this evidence, and never presented it. It's just one piece of the inferential puzzle that the fact finder would take into account. So you can, and that, using that kind of instruction, and the threat to use that kind of instruction has the effect of forcing the defendant to try to bring that evidence into the courtroom, because that evidence is rarely as damning to the defendant as the inference that the jury will draw by not presenting it. And so they often do end up presenting the evidence, unless they have a good excuse. And if they actually have a good excuse, then the judge won't give that instruction to the jury. Yeah, you can imagine illustrations that can show why the two things are different. It's easier to understand in the context of jury trials than in bench trials or judge trials, but you know, the same phenomenon can occur. And a judge could say the same thing, and they do in bench trials in the United States. A judge can say, you know, I'm going to draw an adverse inference against you, defendant, if you don't present that evidence. Doesn't mean the burden of persuasion is on the defendant. It's still on the plaintiff. I mean, I could draw that adverse inference and still conclude that the plaintiff hasn't established their case by the necessary standard of persuasion. So the plaintiff loses.
Sí. Perdón. Ok. Sí, en la quinta fila, por favor.
No, las preguntas
the questions before, the questions before and the answers of the professor are suggesting to me the need of clarifying something here. The quality, the procedural or substantial quality of the rule that is actually presiding a bench trial when there is no evidence, maybe is not so transcendental as the difference between the burden of production and the burden of persuasion in a procedural system such as the Spanish Latin American system, in which there is no symmetry between the activity, the kind of probatory activity of the party and the result of that activity. So it's not symmetrical. The party offering the evidence and with the burden of production can in fact not produce the evidence, and however, it might be, well, the fact might be accredited and the judge might actually deem that right. Why? Because the judge can produce the evidence, and even the evidence produced by the other party can be used in favor of the contrary party. So then there doesn't exist any symmetry between the evidence activity of the parties and the result of that probatory activity. So that is where we see the generation of the need that the legislator be precisely the one to enunciate the rule of the trial, telling the judge how the judge has to resolve when the evidence is lacking, yes, whether he must accept or reject. This is just a clarification that I wanted. I don't know whether it deserves any comment on your behalf.
Bien, muchas gracias.
Well, thank you, everybody. I think there was one hand. We do have a few minutes, so one last question, maybe.
Mi pregunta es la siguiente.
My question is as follows. How, in a specific case, do you assess the compliance of the burden of persuasion if the jury is not motivating the decision? And in this situation, then, the decision is inscrutable. So that is an initial question about juries. And then how do you assess it when it is the judge the professional judge who makes the decision about the proof of fact.
So I think you're asking, how does the law place constraints upon a jury's decision applying the standard of persuasion or the burden of persuasion? Is that correct? In an adversary system? Yeah, there is a certain element of opacity, to the jury's verdict, and frequently we don't require them to, well, rarely do we require them to explain in any way their verdict. There are what are called special interrogatories sometimes, which will ask specific questions that are subsidiary to the verdict and ask them, did you find this, did you find this, did you find this? But in most cases, it's just a straight up liable or not liable, how much are the damages decision. So their decision is fairly inscrutable in that sense. And the only control that exists over that is the exercise by a trial judge either before or after trial in controlling what information the jury receives, or in exercising the authority under this notion of the burden of production to take the case away from the jury. And they could do it before the jury trial, before the jury begins deliberations. If they think that the case is so weak that no reasonable jury could decide in favor of the burdened party, then they can take the case away from the jury. And even after the case is over, if the jury has decided one way and the judge thinks that that was an unreasonable decision, there are various post-trial motions that the losing party can use to get the decision reversed. So those are the only, the only ways to actually control what the jury is doing, because there's no, we don't want to know how that sausage maker makes the sausage.
Bien, antes de terminar, quiero dar un anuncio.
Well, before I end, there is something I would like to say for the students, the master students. And, well, so it would be great for students and teachers of the master to meet outside near the door to the building for a group photograph before we go upstairs for lunch, which will take place in the same place as yesterday. So thank you very much indeed.
Professor Nance, gracias a todos.